Let's wait for 2 minutes more to everybody join in and then we can start.
Sure, ready when you are.
A very good evening, everyone. It's truly an honor to welcome such a distinguished expert with us today. We are joined by Mr. Joe Tirado, a globally recognized leader in dispute resolution with over 30 years of experience. He has handled hundreds of cases across more than 65 jurisdictions, serving as counsel, arbitrator, mediator, and conciliator in some of the world's most complex disputes. Mr. Tirado has represented sovereign governments, multinational corporations, and high net worth individuals across all sections like banking, energy, construction, and international trade. He is also a CEDR accredited mediator, a former ICSID conciliator appointed by the World Bank, and a fellow of Civil Mediation Council. He has contributed extensively to the field through his writings, lectures, and as contributing editor of Global Legal Insights to International Arbitration. So even though we are not physically present, let's give him a warm welcome. Everyone, please drop clapping hands emojis in the chats to welcome Mr. Joe Tirado.
Wow, thank you for that very warm introduction. Lots of hand clapping there. Thank you and good evening to you all. I'm conscious it's later with you. I'm hoping to spend the next 35 minutes or so introducing the topic that I will be discussing. Is the United Nations Convention on International Settlement Agreements Resulting from Mediation, or otherwise known as the Singapore Convention on Mediation, or just simply the Singapore Convention. I think it's appropriate that it comes at the end of your course, because chronologically, of course, enforcement is the result of, comes at the end, although in reality, enforcement should be one of the first things you think about embarking, whether it's litigation, arbitration, or indeed mediation. But without further ado, let me just thank the organizers, Interlegal World, for the invitation to join you and participate in this program. And thank you to you. You're obviously very dedicated to be dialing in at this time in the evening, your time. So thank you for joining me. It's actually quite a timely, in the interest of full disclosure as well, because I did speak on the Singapore Convention a few weeks ago at another event. So anybody that participated in that may well hear similar comments that I made last time, and it's obviously based on that. But essentially, it's very timely that we should be talking about the Singapore Convention, as it's just completed its 6th anniversary. In fact, it had its birthday back in August the 25th to be exact, and it was very much centered around every year Singapore hosts a Singapore Convention Week to really put the spotlight on mediation generally, but in particular international international mediation. So it's great for promoting mediation generally. As we know, it's historically has been quite a hard sell, to put no finer point on it, mediation around the world. It's notwithstanding its many benefits and virtues, it's had a checkered history throughout the world in terms of its acceptance. It's very interesting to see in India the enthusiasm, the real interest in mediation, obviously with the passing of the recent Mediation Act. So there is, again, a timely topic to be discussing about mediation. So it's kind of coming of age. It's for those of us that have been involved with alternative dispute resolution, which is this is often referred to, for reasons I'll explain in a minute. I kind of resist calling it alternative. It's a little frustrating that it takes so long, but the good news is I think we are making progress across the world. And so you are seeing, I think in the last 50 years, it's the US that led the way. In the UK, which is my jurisdiction, we kind of picked up the baton towards the end of the 1980s, early 1990s, and we have made considerable progress. There's still a long way to go, to be honest, but it is ever more being adopted. And I should just say with the caveat, these are my views. I don't partly designed to be provocative, so we have a debate and question after my time is concluded. I hope that you will have some questions of your own that we can explore together. That's how we all learn. But obviously anything that needs clarifying as well, that's the opportunity. If there's any real burning question, feel free to interrupt me as I'm going along, but hopefully there will be a chance to pick up your queries and comments at the end of the session. But the reason why I kind of push back about it being alternative is that I think in many ways we have succumbed to the what I term the industrialization of legal disputes. I mean, big law generally across the world, big and small law, have monopolized disputes. And so when you have a problem, the kind of knee-jerk reaction is to hit the litigation or arbitration button. And so that has become the default primary way of resolving disputes. I don't quite understand how that has happened. I mean, in some ways I do, but in reality, mediation is by far the most natural form of dispute resolution, which we're all qualified, unlike litigation or arbitration that requires training, experience. We're all naturally qualified mediators, and we mediate all the time in our families, with our friends, with our neighbors, with our colleagues. So in my mind, it's really the primary source of dispute resolution, not the alternative. Indeed, it should be litigation and arbitration that are the alternatives. But I'm afraid, the kind of the way of the world. And I think I would go further as to say that rather from being alternative in any event, it's really more a question. The other pushback, I would say, that it's a question of being appropriate. So there are a number of tools we have in our dispute resolution toolbox, and not every, you don't have to automatically rush to arbitration. There are different things, and mediation is just another tool. And I think it's using the appropriate tool for the appropriate issue that you have in front of you. And I think, again, that's kind of forgotten, although, as I say, we are getting it's certainly post-COVID, interestingly enough. I say it's not without coincidence that terrible time that infected the whole world. I think we've kind of come out of that wanting to do things differently. So in some ways, while mediation has been around for a long time, I think there has been a bit of a renaissance. And indeed, I would say not only has it been around for a long time, it's been around for centuries, if not millennia. But as I say, we've only seen traction for mediation primarily in the Western Hemisphere, taking hold in the last 20 to 30 years. The main jurisdictions that we have seen real developments are UK, Italy in continental Europe, Ecuador in South America, and now, of course, as I've already mentioned, in India as well, we're seeing. So it is, and I think China and the Far East has always had a tradition of mediation. and has been more open to it, and indeed continues to be more open to it, I think, in commercial context. But generally, for the rest of the world, it's really coming of age now, as I've said, and it's moving on from just the domestic setting to international mediation. And certainly as world commerce and international trade grows, I think we've become ever more connected, and therefore there's an increasing need for efficient dispute resolution mechanisms to manage the inevitable disputes, because they are sadly inevitable, that arise. And of course, I think we've seen, with the considerable costs and delay involved in litigation and arbitration, and also the growing risk of being able to enforce both judgments and awards, has led to further greater frustration in the existing system, and a growing focus on what have been termed alternative methods of dispute resolution, and most noticeably mediation. And I think great effort has been made to promote mediation in the last decade in particular, and to remove obstacles, whether these are actual obstacles or perceived obstacles, to enhance its wider use and exception. And one such area I think that has been a concern is that the use of international mediation was often limited by the difficulty of enforcing settlement agreements across different countries. Now, whether you consider this to be a perceived or real concern, I think is somewhat moot. In reality, I think in practice, one tends to find that one of the advantages of mediation is that the settlement agreements tend to be enforced and honored, complied with, more than you may find in the situation where you have a judgment on award to enforce. And I think that makes sense, because it's the product, the creature of the parties themselves reaching an agreement. It tends to be something that they honored. It's not something that's been imposed on them by a judge or an arbitrator. So it's an interesting concept. And I think in many ways, all this effort that's been given to the Singapore Convention, in many, I kind of refer to it as a solution in search of a problem, because, as I say, for the very reasons that I've just described, I'm not sure in practice that it is such a big problem. But nonetheless, I think the important point is that to remove any obstacle, and even if it's that perception, to remove that, it's got to be benefit. Anything that it promotes mediation, I think, has to be benefit. And I think we have to be grateful to our Singapore colleagues, who have been very strategic, I think, in their approach regarding the Singapore Convention, including getting their name in it. But they have been very determined in its promotion. They have this annual week to promote and remind everybody about the Singapore Convention, but also, as I say, to discuss about mediation generally. So I think anything that removes these barriers to make mediation more attractive to businesses and individuals, particularly those engaged in cross-border transaction, has to be seen as a positive move. So that's kind of sets the scene, if you like. I'm just going to go back a little bit into the history, because the work on the Singapore Convention started about 12 years or so. And I was fortunate enough, I can't claim to be the father, but I always like to consider myself at least one of the godfathers, because I was involved during my tenure as a co-chair of the IBA Mediation Committee. We set up a working group to look at this very issue. As I say, it was somebody else's idea, but we were then looking to see how we can develop it. And it was interesting that it soon got traction. Actually, the US State Department got very interested in this. And then UNCITRAL, part of the UN effectively, really led the way and the charge. And so what we saw was a great push to develop something like the New York Convention for Arbitration. That's the recognition and enforcement of arbitral awards. But that is for arbitration awards and not mediation. So in response, the United Nations Commission on International Trade Law, that's what I've already referred to as UNCITRAL, began working on a treaty to bridge this gap. And at its 47th session, back in July 2014, the UNCITRAL Commission agreed that the Working Group 2, that's the one on dispute resolution, should consider the issue of enforcement of international settlement agreements resulting from conciliation, otherwise known as mediation proceedings, and to report to the Commission at its next meeting, the 48th session in 2015, on the feasibility and possible form of work in that area. So it's all relative recent history, last 10 years this has been going on. So back then in July 2015, the Commission took note of the consideration of the topic of the Working Group 2 and agreed that Group 2 should commence work to identify relevant issues. So the concept was accepted in 2015 and then effectively the green light given to develop what later became the convention. And so was given the green light to identify relevant issues and develop possible solutions, including the preparation of a convention, model provisions, or guidance texts. And the Commission also agreed that the mandate of Working Group 2 with respect to the topic should be broad to take into account the various approaches and concerns. Now, I kind of mentioned at the beginning, it is effectively like a mini United Nations. You had 85 member states and 35 non-governmental organizations participated in the deliberations, which took place over 6 sessions. That's not the entirety of the United Nations. That's something like 192 countries, if I'm not mistaken, but a large chunk got involved. And I think it is worth just pausing and just conceptualizing how many people were involved in the creation of this document and how many those who are specialists in the area. So it's had an enormous amount of input from leading both academics, practitioners, clients as well, inputting into the whole of this creation. So through the deliberations, Working Group 2 reached a compromise, and it was a compromise because, believe it or not, there was one would think that it would be relatively straightforward, but actually there were different views as to how far the convention should go. Inevitably, I think when you're creating anything, how much of it should be compulsory? Is it buy-in? Is it buy-out? For example, probably is one of the biggest issues. Do you impose this on people or not? And there's a tension there when you're dealing with consensual subject like mediation to effectively impose it or not. But upon which the Commission expressed support for Working Group 2 to finalize this work by preparing a draft convention on international settlement agreements resulting from mediation, as well as draft amendments to UNCITRAL's model law on international commercial conciliation, which was back in 2022. So a big push to kind of promote mediation. And eventually the convention, or what became the convention, was finalized at the 51st Commission meeting. So it started at the 47th, had several rounds, 51st meeting, which came to a close in July 2018. And the amended model law that I've referred to, this the UNCITRAL model law on international commercial mediation and international settlement agreements from mediation, was adopted at that session in July 2018. In December 2018, the United Nations General Assembly, by consensus, passed a resolution to adopt the United Nations Convention on International Settlement Agreements resulting from mediation, and recommended that the convention be known as the Singapore Convention on Mediation, and authorized the signing ceremony to be held in Singapore on the 7th of August 2019. As I say, we've just had a couple of months ago now its birthday, so 6 years it's now been in place. And I think it's probably fair to say, without being overly dramatic about it, it's truly a landmark multilateral treaty designed to offer a uniform and efficient framework for the enforcement and invocation of international settlement agreements resulting from mediation. I think when you see the level of input and the actual relative speed it's taken to put together, using terms like landmark, it's not unreasonable. And I think prior to you've got to look at, well, what was the situation prior to the Singapore Convention coming into force? Well, enforcing it, if you had a mediation agreement across borders, could prove very difficult, leading to delays, increased costs, and uncertainty. With the caveat, as I said, in reality, that situation was not super common, but it did happen. So previously, there was no uniform framework. Parties effectively had to relitigate or start enforcement proceedings locally, which limited mediation's appeal. And so the convention helped solve this problem by providing a clear, predictable process for recognizing and enforcing mediated settlement agreements across signatory countries. That's the history. I'm just going to look at the convention in a second, but just pause to say that normally, as a wider consideration for settlement, you have essentially two options. Certainly in the UK, the mediation agreement is a separate agreement from every other agreement that is the subject of the dispute. And so it's a creature of contract. And if parties don't comply with the agreed terms of their mediated settlement, the option is to enforce the mediation agreement. The alternative is to say all bets are off and everything's up for grab, and you have to start, you can proceed with your original claim. The difficulty with that is you've still got all the burden of proof, all the issues that would be involved with any litigation and arbitration to overcome, but essentially it's all bets are off and you start again. The beauty of a claim under a mediation agreement is effectively there's no burden of proof other than to say the parties had reached this agreement, this is it. And generally that's not a difficult or hard to show, and you can enforce it as a simple breach of contract without having to go through all these all the proof. And so that may be a possible way of enforcing, but doing it cross-border, as I've already mentioned, is certainly very complicated. So with that as an aside, let me turn to the convention itself, if I may. And in fact, the preamble to the convention recognizes, it says the following: it recognizes the value for international trade of mediation as a method for settling commercial disputes in which the parties in dispute request a third party or persons to assist them in their attempt to settle dispute amicably. Right up front, basically, this is a promotional instrument. It has practical benefits, of course, but it's there to promote mediation in the widest sense. It says right up there, it's opening words of the preamble. It goes on, it says, noting that mediation is increasingly used in international and domestic commercial practice as an alternative to litigation. And then considering that the use of mediation results in significant benefits, such as reducing the instances where a dispute leads to the termination of a commercial relationship, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice by states. Again, it's an advert for mediation, but coming from the states themselves. And it basically says that convinced that the establishment of a framework for international settlement agreements resulting from mediation that is acceptable to states with different legal, social, and economic systems would contribute to the development of harmonious international economic relations. That's all in the preamble that I'm reading for you, and that's what it's about. It's to try and oil the wheels of commerce, avoiding litigation, and it's front and center of the rationale that's behind this convention. So that's in the preamble. Let me turn to, it's a very short convention. I commend it to you to read. It's very readable. It's not overly complicated. But turning to some of the key provisions are, well, if we look at the scope is in Article 1 of the convention. It's important. I read this slowly because I'll put deliberately emphasizes on some key words here. It says the convention applies to mediated, first key word to highlight, international settlement agreements. So I'll stop there. It's designed for parties from different states. Domestic mediation is not covered by the Singapore Convention. Equally, is the same with the New York Convention, for that matter. These are recognizing there are two parties from different states, resulting from the facility, and it has to come from the agreement reached from facilitated negotiation after disputes arise. So in addition, so international one. Number two, it's mediation settlement agreement must be commercial. So it's not covering family employment. It's a commercial dispute. So this excludes, as I said, transaction by consumers for personal, family, or household purposes, or relating to family inheritance or employment law. It's the focus is primarily commercial transaction. And so the convention does not apply to settlement agreements that are enforceable as a judgment or arbitral award. They're dealt with separately. Articles 2 to 4 cover the issue of recognition and enforcement. So countries undertaking the convention agree to recognize and enforce these agreements if requested, provided certain formalities are met, and that's important. For example, the agreement must be in writing. The parties should have achieved it through a formal process, which is the mediation generally. So if there's an issue, this is one of the few occasions, perhaps a mediator who will hopefully have excluded his liability, but may be called to help provide evidence that the process was indeed followed. So courts can review, but only check if the agreement is valid. It's not there to reassess the substance of the settlement itself. I mean, basically, parties can agree whatever they like, so long as it's legal. Settlement agreements can be directly enforced in the competent authority of a party state in accordance with its rules of procedure under the conditions laid down in the convention, and it will lay that down. So you have to identify the competent authority and what are the rules of procedure. It's not overly complicated. Those that have ratified it, there is a procedure to follow, but it's not overly onerous. There are exceptions, though, and the competent authority of a party state to the Singapore Convention may refuse to grant relief on grounds laid down in the convention itself. So you should be aware of it. So the main exceptions are the following: if a party to the settlement agreement was under an incapacity. So this is all to do with due process, essentially. So somebody needs to go in with their eyes wide open and have the capacity to enter the agreement. If the settlement agreement is not binding, null and void, inoperative, or incapable of being performed under the law to which it is subjected, or it has been subsequently modified. In addition, there was a serious breach by the mediator in terms of applicable mediator standards, or failure to disclose circumstances that raise doubts as to the mediator impartiality or independence, without which the party would not have entered into the agreement. Again, I emphasize these are all kind of not dissimilar from New York Conventions for arbitration type benchmarks to overcome, and all really about due process and transparency. In addition, if granting the relief would be contrary to public policy of a party state. This is slightly problematic because, as with the New York Convention, public policy is extremely nebulous and changes over time in terms of the individual states' views as to what they consider might be advantageous for them and their nationals. So that's one, I think, to watch to see whether or not this is invoked in practice or not. I mean, I'm not aware of anybody having any awards being challenged yet, or failure to enforce on the basis of public policy. But as I say, it's early days. We will need to see. And then finally, the parties to the New York Convention have been given the option to make the following reservations when signing the Singapore Convention. So in addition, it's whether to qualify that the convention would not be applicable to settlement agreements to which its government or other public entities are a party. So that's carving out claims, commercial claims, including against the state or state entities. Or this issue that I mentioned at the beginning, to adopt an opt-in approach, which provides that the convention only applies to the extent that the disputing parties agree to its application. The status is having an opt-out at the minute, so it applies unless you've decided you don't want it. So it's but there may be a reservation where countries will say we will sign up to it, but only if it's specifically and expressly stated that's what the parties want. The general position is, I think you see a bit of both, but you need to be careful, and when you're looking at enforcement, to check what reservations have been made. In relation to procedural aspects of the convention sets out the process for parties to request enforcement, including the need for supporting documentation and compliance with formalities. In short, it provides a balanced framework, strengthening the enforceability of mediated agreements. So it's, again, to try and have a level playing field and a common understanding of what is required. In terms of its the current status, there are 46 countries, including the world's two largest economies, that's United States and China, as well as 3 of the 4 largest economies. That's China in Asia, that's China, of course, India and South Korea have signed the convention on the day it was opened. Another 24 countries attended the signing ceremony in Singapore to show their support for the convention. So, you've got right from day one, you've got 70 countries in support of it. On the 25th of February 2020, Singapore and Fiji became the first 2 countries to deposit their respective instruments for ratification. So signing is one thing, it's ratifying the convention. And the actual convention, and they did that, they ratified it before the convention actually came into force, which was in September 2020. And as of August, the convention has been signed by 58 signatories. That's 30% of the United Nations countries. So it's a significant number, and 18 parties. Costa Rica was the last one, I think, to ratify in March 2025. So it's a global reach, and it has a mix of developed and developing nations. That's essentially it in a nutshell. As I say, it's very, you can go on the Singapore Convention website, which is hosted by our colleagues in Singapore, for more information, or indeed look at UNCITRAL. But I think looking forward and future evolution, and I'm going to conclude with these comments to, as I say, open the floor up to any questions, comments, and thoughts of your own. But obviously, it's the potential for expanding membership. So I think it's pretty impressive that they got 30% sign up in 6 years, compared to, it's taken 66 years for the New York Convention to get the kind of level of 170 odd countries signed up to that. So they've got a way to go to catch up, but it's looking good. But it needs more countries to sign and ratify. The US, I've mentioned, China, India, of course, UK has not, although there is moving ever closer to doing it, and the European Union. So there are important jurisdictions who are supportive of mediation, but have yet to take that stage to ratify. I think, to be fair, I would just pause that in the intervening years, I mean, there's a lot been going on in the world with global wars, pandemic issues. People have been distracted. This may not necessarily be top of the agenda. And I'm sure people will follow through with ratification to keep the momentum going. I think, and so the impact will be, I think, greater acceptance and trust in mediation over time. This is an important constituent part in that, but it's part of the wider package as well. And I think the challenges going forward will be ensuring uniform adoption and implementation, as I already kind of put a marker down. whether or not we see how many countries prefer to have the opt-in solution rather than the default opt-out, how many countries oppose settlement on the basis of the vagaries of public policy. That will be interesting to see going forward. I think that certainly will be one of the challenges. But I think with that general introduction, which I hope was help and use to you, let me just conclude by saying I think the Singapore Convention truly has been is a transformative step in global dispute resolution. It encourages the use of mediation and reduces reliance on court litigation and arbitration, which is what parties, after all, say they want. There is data out there to indicate that parties are fed up with the old status quo of litigating, arbitrating, the cost, the delay, and of course, increasingly the issues of enforcement of those awards in arbitrations as well. So this is an important step in terms of continuing that momentum. As I say, perhaps not as fast as one might like, but it's going in the right direction. And I think the convention's truly global reach is expected to expand further as more countries see the benefits of facilitating cross-border mediation enforcement. And I also think it's a subject close to my heart, as those who know me know. It's also part of the wider, not just for commercial arbitration in the sense of the between private parties, but I think it's also part of the wider move and the beginning to see the settlement of disputes between states, investors and states, and there's no reason. And this is all part of that, I think, opening up mediation and helping people understand the real benefits of mediation, and that it is far more flexible and able to deliver far more long-term enforceable, feasible agreements than, say, an arbitration or litigation award. It can involve, multi stakeholders as well. So all of this has got to be positive, albeit, as I say, with the caveat, I think you have to see it as a whole, as a yet another tool in the toolbox of dispute resolution. It's not a panacea. It doesn't necessarily replace arbitration litigation, but used in the right way at the right time, and importantly with the right mediator, I think it's an important step forward for dispute resolution at an international level. So I haven't, I think that's about 40 minutes or 35 minutes. I'm happy to just pause there, take some breath, and invite you please to any questions you have, or indeed any comments you have. You may disagree with what I was saying, but the whole point is to provoke some debate and share views. Who would like to go first? I see.
Hello.
Hello, is that Vijay?
VIJAYALAXMI, sir, thank you so much. I just wanted to understand if you could elaborate that if there are so many countries signing up for the convention, what is preventing them, or what is making these countries ratify it? Because without ratification, the whole purpose of signing it is really not helping.
Yep.
So what is stopping them? What is the challenge for all these countries?
Yeah, no, it's a great question. I think, to be honest, it is frustrating. You go to all this effort, you think you've done all the hard work. This should be the easy. I mean, of course, there is a process inevitably, but it is a little frustrating how people, I think something like 18 have now ratified. In defense of all these countries, including my own, as I alluded to, or indeed said, I think their legislative agendas have been full with lots of other complicating things in the world. So it's not, in the overall scheme of things, it's perhaps not the most important, is what they would argue, probably. But I think there is a genuine will, and I don't think it's people getting cold feet. It's more that parties have been focusing on what they perceive to be more urgent matters, as I say, post-COVID. Lots of, so from the UK perspective, but I think it applies to many of these other jurisdictions. We've had a change of presidency in the US and, change of domestic policies and focus on other issues. So this kind of thing kind of falls by the wayside. But I think your question is well made, because I think there is a danger. We need to keep the momentum going. But this is where I'm grateful. As I say, I think the Singaporeans, I always take my hat off to them. I think they're brilliant at marketing. And I think this yearly week, which is just focused on it, and they get the great and the good to come to it, keeps the pressure on, keeps it visible. And we are seeing slowly but surely they would come on. But it is frustrating. But I would like to, India should be signing up soon. It's now with the mandatory mediation. I would hope that they would be signing up and sending a powerful signal. But I agree with you. It needs to be ratified. Signing is not enough. It has to be ratified.
I just want to add one more point, sir, that have there been any kind, so the whole idea is let's watch and see if this is really working well. Let me just see that countries who have ratified, are they doing well with this whole arrangement? So we are watching, we are taking a back seat and watching. My question is, have there been any goof ups which has made me rethink as a country that should I ratify it? Anything like that which has happened?
No, not that I'm aware of. And as I say, the reality is they need to decide really is whether there may be issues, and I can see that some, and this was part of the discussion, I think, when it was being debated through those years about whether how much you impose it on people, whether you have that default, it's there unless you exclude it, or you need to be able to, for it to apply in that country, you need to expressly state you want it. And some countries have gone down that route, and some countries have said we're not going to have it apply against our state or state entities. So there's some debate, but they can do that, and they're perfectly easy for them to make that suggestion without, I think, showing any concern, cold feet, or second thoughts about entering into the convention. I do genuinely think it seems to be the logical. I hope I'm not being naive about it. I think it's just partly that having done the hard work, that's invariably, that tends to be the problem. Unless you do things pretty much straight away, then people think they've signed the convention and they go off and do other things. But I think it has come down the agenda a little bit. But I don't necessarily think that's a suggestion that parties feel that they've made the wrong thing either in signing. And I'm not aware of any major problems or any case. I mean, the reality of it is there should be relatively few cases coming up under it, because it's there to provide a comfort that if there's a problem, you can go and enforce. But as I kind of said right at the very beginning, in practice, in my humble experience, it really rarely is a problem, because parties want it to work. They want to have their ongoing relationship. And indeed, what I have the few times when parties don't comply, it's often a money issue. So part of the settlement agreement might be they know that the other party's in financial difficulties, but rather than push the nuclear button and push them over the edge, they try to give them a bit of breathing space, agree negotiating installment options. But sometimes it still just doesn't work because the economic circumstances, even with that more generous approach, it's still the company not viable and will go under and is unable to pay. It's not because it doesn't want to pay, it just doesn't exist anymore. But they're relatively few and far between in my experience. And so I don't think one will be seeing a lot of case law around the world on it, because I think for that very reason, there shouldn't be that many cases. I think what will be interesting, and I think will be a terrible press for any of those countries that somehow you rely on some vague notion of public policy as to why they don't enforce, when it's clear that that the convention applies and they come up with a reason for dodging it. But I think most jurisdictions that have signed up for it at least are behind the concept of mediation and moving forward. I mean, regimes change, cultures change, but I think generally I'm pretty optimistic about it. But it is a little frustrating, and you keep seeing moves here in the UK, for example, to push the government, who say they will sign, but it's a question of when.
Thank you, sir. Well explained. Thank you.
Sir.
Yes, please.
Good evening, sir. Sir, kindly clarify, in such a scenario, when a country is only signatory but not yet ratified, and if entity belongs to that country, mediation can happen in that situation or not?
Yeah, no, it can certainly happen, and it can certainly still be enforced. But the trouble is, you don't have something you can go to. In that scenario, it's if you need to enforce in that state, you don't have an automatic right of enforcement to say to the court of that host state, look, here's my mediation agreement. It's been entered properly, so everything's legal. Please enforce it as if it's a domestic judgment. That's the simple, short, and unless and until it's, and this is going back to our last question, that's the practical importance of it, all of this, because unless signing, it shows that it's only a statement of intent. It's the ratification that has the practical benefit. And so the reality of it is, if you needed to enforce in that particular host state, you will have, you may have problems if it's not been ratified.
Oh, thank you. Thank you.
Thank you for the question.
So I have a question here.
Yes, Sunil.
Yes, thank you so much, and warm greetings, Mr. Joe.
Oh, I'm impressed. You're all very active at this time in the evening, so keep the questions coming.
Yeah, thank you so much. Thank you. Now, based on your insights about the convention, now I've got a couple of short questions, and I hope you're the expert to answer these. I want to understand, when already we have the New York Convention, what was the need for a new convention like Singapore Convention to come up first? Second question.
May I just deal with that?
Yes, please. Yes, please. Sure. Yeah.
No, there's until somebody tells me to shut up, I'll keep going. I think we have time. The reason is very simply, it only applies to arbitration agreements. The New York, it's not mediation. So, and in fact, even if you have the mechanism for enforcing an arbitration award is through even an arbitration award by consent, which would be similar to a mediation agreement, if you think about it, is through the New York Convention. It's not, if it's the product of a mediation, this is why this convention has been brought in.
Okay, got it. Thank you so much. Now, the second question that follows is, now as mediators, how can an individual be empaneled with the Singapore Convention or become an international mediator?
Well, that's a great. Yeah, no, the Singapore Convention is not an institution. There is no empanelment. It depends on your jurisdiction. Taking my own, for example, the UK, we have, many people may be surprised to know, we don't have a mediation act. There is no law saying who can and can't be a mediator. There are lots of kind of soft law things, guidance for ethical requirements. I mean, obviously, you'll be subject to normal laws of accepting a bribe, for example, those kind of things. But actually, this is not, it's unregulated. There are ways of becoming accredited in institutions, but the answer to your question is really, it depends on your home jurisdiction for accreditation. And I would strongly encourage those who are not accredited to get accreditation, because it does give you that kind of be able to demonstrate that you've had the training. If it's through a reputable, well-known institution, that gives parties confidence that this isn't just somebody that stepped off of the bus who calls themselves a mediator but doesn't. And I think that accreditation, there are many now in India as well that offer it both online and in person. I think that's a really important first step. And then in reality, in terms of how you get into the international, it's a little bit of kind of luck of the draw, what work comes your way. but inevitably, it's clients will select you. Well, institutions may nominate you, but clients may select you because of your exposure to international work in the past. There's no kind of, but there is, if you're interested in state, investor state, there are one or two. There's additional accreditation to become an investor state mediator too, which again I think gives parties some comfort that you are dealing with someone who has at least understands the fundamental issues that arise in the complexities of an investor state. But that's quite esoteric on one level. Just commercial mediation. I mean, I think just a lot of that depends on what comes your way and how much. Clearly, the more work you are doing in your private capacity as an international lawyer, for example, then perhaps the greater opportunity there might be to do international mediation.
Okay, sure. Thank you so much, sir. Thank you.
Thank you, sir. Any other comments or?
Thank you, sir, for the wonderful presentation and clarity.
Well, thank you for your questions, and as I say, sticking with me. I don't want to drag this out any longer than normal than I need to, given the hour for you. But thank you so much for sharing this time with me and for your questions. And I encourage you all to read the Singapore Convention and encourage India to ratify it.
Thank you, Joe.
Thank you so much, sir. Thank you.
Thank you. Our moderator, are we free to go?
Thank you so much, sir, for wonderful session.
Thank you very much, sir. Thank you very much.
Thank you so much, sir, for a wonderful session. I believe that students are helped with this international insight, and particularly what we have discussed on Singapore Convention, right? And one question I have received, sir, that is, what is the difference between Geneva Convention and New York Convention? This we know it very well, but your insight would greatly help students. Difference between New York Convention and Geneva Convention.
Sorry, the Geneva and which one?
New York Convention.
Okay, right. Very well. There's the Geneva Convention in terms for war. I think we're not talking about prisoners of war and that type of convention. There is a different one which is it's similar to the New York Convention. Effectively supersedes the Geneva Convention. There was a convention for the recognition of foreign arbitral awards that predates the New York Convention, but the New York Convention essentially supersedes and is the premier convention for the recognition and enforcement of foreign arbitral awards. But they're both concerned with arbitration as opposed to mediation.
Thank you so much, sir, for your insight and helping our students with the topic.
Whose voice is that? Is that Akshat?
This is Amaresh Patel, sir.
Oh, thank you, Amaresh.
Thank you so much, sir.
Okay.
Thank you, sir.
Good evening to everybody.
Thank you and good evening, sir. Thank you.
Bye.
Thank you and good evening. Good evening, sir.
Admin ma'am, class is off.
Yes,
Yes, class is off. Students may leave.
yes, students,
Thank you.
you can leave the class.
Thank you.
Thank you.
Thank you. Thank
About
you.
the session.
Thank you.
Thank you.